The definition of evidence can be found in Section 1 of Rule 128. Okay? And as to admissibility, okay, dalawang requirements. It must always be relevant and the evidence must be competent. And who determines whether or not the evidence is relevant or competent? It's always the court. When is an evidence relevant? Okay. Again po, meron po ako ibibigay na materials. This is updated. And please do not disseminate the materials. Okay? Please, wag nyong ipagkalat yung materials. This is only for those who are enrolled sa CSU na criminology and for the purpose of board examination. Relevant, and evidence is considered to be relevant when it has a relationship or relation to the fact in issue as to induce belief in its existence or non-existence. The collateral matters from the word itself, collateral. So, hindi sila yung main issue. So, extra, kumbaga, collateral or extra matters. Okay? Matters which have no direct connection to the fact in issue. Okay? The example, in a suit on a promissory note by Pedro against Daniel. Okay? The fact that Daniel did not pay Albert on another note is a collateral matter. Bakit po? Kasi the fact in issue is the debt of Daniel to Pedro and not the debt of Daniel to Albert. So, if the issue herein is the failure to pay or collection of money filed by Pedro against it must only pertain to the issues, okay? Issues between Pedro and Daniel and not of Daniel and the other persons, or in our given case, it's Albert. Another, allowed ba? Is evidence allowed or is evidence on collateral matters allowed? Collateral meaning extra, hindi kasali. Okay? The answer there is no. Okay? Evidence on collateral matters are not allowed. Bakit? Kasi nga they are matters that has no connection with the fucking issue. Okay? However, there is the certain exemptions, okay, provided in Section 4 of Rule 128. Madali lang po ang evidence natin. Sobrang short lang po ang evidence natin. So, except when it tends in any reasonable degree to establish the probability or improbability of the fucking issue, then evidence on collateral matters may be allowed. So, example of collateral matters, okay? Evidence of accused flight, okay, may be admitted to show he's guilty. Okay? So, for example, ang proof mo is that plane ticket na aalis si accused. And since he is an accused, of course, there is a case filed against him. Okay? In that case, that is only collateral evidence. Is evidence allowed on that matter? The answer there is generally no. But if it tends in any reasonable degree to establish the probability or improbability of the fucking issue, then evidence may be allowed. Paano naman ang competency, ma'am? Ano ang competency? Okay? Under competency, okay, always remember po, this is the rule. Even if the evidence is relevant, kahit importante ang isang ebidensya, but if it is excluded by law or rules of court, the evidence would be inadmissible due to incompetency. Okay? Always remember the letters A, R, C. Okay? Admissibility is equal to relevancy plus competency. So, RC is equal to admissibility. R plus C is equal to admissibility. Relevancy plus competency is equal to admissibility. Ang ganda-ganda sana i-discuss to sa blackboard kasi ito yung tinuro ko nung last ako nagturo dyan sa Cagayan State University. Ang ganda-gandang ituro ng evidence. Ang saya-saya. Okay? Pero since review nito, medyo paspas tayo and I hope na makahabol po yung mga iba na medyo hindi pa nakapag-review sa evidence. Maiksi lang po ang evidence, sobrang iksi. Kayang-kaya basahin ng 4 hours. Okay? Here, always remember again, ang relevancy there must be ang relevancy, di ba, nag-i-start sa letter R. Okay? Relevancy, relationship. So, there must be a relationship to the fact in issuing evidence. Sa competency naman is excluded ba yan ng court or ng rules of court or ng law? If yes, that is inadmissible. Because ang equation natin, R plus C is equal to admissibility. Huwag niyong kalimutan yan. Of course, we have the exclusionary rule. Okay? Alam niyo na yan. Tsaka yung fruit of poisonous tree. Okay? Exclusionary rules are present in the rules of court. For example, okay? Example ko, those relating to various disqualification rules and privileges. Okay? It can also be found in the Philippine Constitution. Okay? Under Article 3, Sections 2 and 3. Okay? The unreasonable search and seizure, right to privacy communication and correspondence. Okay? Pati yung anti-wiretapping law nyo, yung RA 4200. Okay? And Section 12 of Article 3. Okay, the rights of persons under those persons under custodial investigation. And Section 17 or the right to against self-incrimination. Question. Hindi, wag na lang ito. Hindi nyo naman mag-gets. Okay, let's go to the different kinds of evidence. Okay? Simpleng-simple. Okay, tatlo lang. Evidence. O, diba? Tatlong syllable. Tatlo lang din yung kanyan. Tatlo ang nanay. Okay? Ang evidence, si evidence, tatlo pala yung asawa niya. Okay, babaero si evidence. Si documentary, si object, at saka si testimonial. Okay? DOT. Si documentary, si object or real, at saka si testimonial. Ang other term for object is real evidence. Okay? Yung mga documentary, obviously those that involve document. However, it must be the content of the documents. Okay? Paano kung documents siya, pero yung existence of the document? That is only object evidence. If the question is whether or not there exists a book entitled Ang Pusong Bato, ganun, that is object evidence. If the question is whether or not, okay, it was written in the book that ang magmahal ng iba ay masama. Okay, example lang yun para matandaan nyo. If it's the content itself ang issue, okay, then that is a documentary. Pero kung yung existence ng book mismo or anything, di ba, ang object evidence, anything that addresses the court senses, again, we have 5 senses, plus the common sense, we have the 6 senses, that is on the joke. Okay? And lastly, you have your testimonial evidence. Under your testimonial evidence, it consists of statement of a witness offered to the court. Ma'am, paano yung judicial affidavit? That is considered to be your testimonial evidence. Ma'am, paano yun? Yung content nung document, nung documents ang... Teka lang, may nag-chat. Okay? What if it's the content of the document itself is still the testimonial evidence? If it's offered, okay, as the direct testimony of the witness, that is testimonial evidence, not the documentary evidence. Okay? Always remember, in testimonial evidence, pwedeng nakasulat o pwedeng oral or live. Okay? Next one. Always remember po, doon tayo sa unang asawa ni evidence. Okay? Kay documentary. Ito yung original na asawa niya. Okay? It can be any writing, recording, pwedeng picture or photograph, any material containing letters, words, sounds, okay? Numbers, figures, symbols, or their equivalent or other modes of expression offered as proof of their content. Huwag niyong kalimutan yung content. Okay? Content, that is documentary evidence. Anong ibig sabihin ng photograph dito? May mga picture, ma'am? Documentary yon? Yes, sabi ng batas. A photograph means any photographic image or its equivalent stored in any form. Okay? It can be a still picture, yung mga hindi gumagalaw, pwedeng drawing, pwedeng x-ray, pwedeng stored images, pwedeng motion, pwedeng video. Okay? Any mode of written expression. Next one. Yung recording, anong to? Anong ibig pong sabihin nito? Any letters, words, numbers, or equivalent, or their equivalent. Yung sounds, saan siya under? Documentary. Example, mga speech, mga conversation, mga oral communication, those are considered to be documentary. So, kung i-record mo yung napag-usapan nung pumatay at saka nung kasabwat niya over the phone, na i-record mo yun, those sounds, that is considered to be documentary evidence. Again, huwag niyo kalimutan, if the evidence offered, okay, it's the contents will be submitted before the court, that is documentary evidence. We have this so-called original document rule. Bago to, ha? Bago po ito. This is one of the amendments, 2020 amendments. Okay? Original document rule. Lagyan nyo ng star to kasi bago to. For sure, lalabas to sa board exam niyo. Dati, ang meron tayo is, sa documentary rule is, ang tawag nito, yung secondary evidence, ganun agad, di ba? Kung maalala nyo, to may bago tayo, original document rule. Ano ba tong sinasabi ko? Original document rule. And the best evidence rule, okay, yung alam nyong best evidence rule noon is now known as the original document rule. Okay? Bakit nila pinalitan? Kasi that is in order to avoid confusion. Kasi sa totoo lang, kung papakinggan mo, best evidence rule, di ba parang yun ang pinaka-importanting evidence. O ibig sabihin, kung meron na yun, parang mananalo ka na ng kaso. Di ba? Parang ganun yung dating. Pero now, the Supreme Court Committee already changed the name of the best evidence rule. It's now the original document rule. Okay? And this rule only applies to documentary evidence. So, si evidence at si documentary evidence, may anak sila. Number 1 is si original document. Ito yung panganay nila, panganay na anak. So, the original rule provides that when the subject of inquiry is the contents of a document, okay, a writing, a recording, or a photograph, no evidence is admissible other than the document itself. Again, ang original document rule only applies sa unang asawa. That is the documentary rule. Hindi yan nag-a-apply sa testimonial at saka sa object or real evidence. Question. The prosecution witness, okay, si Pedro, yung witness ng prosecution, he testified na sabi niya, he saw a CCTV footage of the accused robbing the bank. The defense counsel nag-object on the ground of original document rule. The prosecutor argued that the CCTV footage is not a document since it is not a writing. Video yan, sabi ng prosecutor. Question, should the defense counsel objection be sustained? Okay. The answer there is yes. Because, sabi ng batas, photographs which includes still motions or pictures or videos are expressly included in the definition of documentary evidence. Oo, walang nakasulat sa mga picture, sa mga photographs, but they are expressly listed and enumerated or included in the documentary evidence. Hence, that the objection of the defense counsel should be sustained. Next. When will you going to consider a document original? Kailan ba nagiging original ang isang document? Okay? Ma'am, paano kung yung may photocopy? O, yung pinakauna bang na-print, yun ang original? Okay? We have the so-called original and the duplicate. Okay? The original, okay, includes those that negative or any print therefrom. So, yung mga photocopy niyan is still original. Yung duplicate, this is the meaning. A duplicate means a counterpart produced by mechanical, photographic, chemical, electronic, or other equivalent process or technique that accurately reproduces the original. So, a manual copy of the original is not a duplicate since it does not accurately reproduce the original. Question. I have a question for you. Pedro, the proponent, presents in evidence a photocopy of a letter written by the adverse party, Ana. Ana yung kalaban niya. So, nag-produce si Pedro ng ebidensya, yung photocopy ng letter na sent ni Ana without accounting for the non-production of the original letter. So, produce na yung photocopy without showing or providing the original copy. Sabi ni Ana, objection, Your Honor. Sabi niya, that is a violation of the original document rule. Okay? Sinong ifa-follow natin? Si Pedro o si Ana? The answer there is Pedro. Okay? The objection should be overruled. A photocopy is a duplicate since it is a counterpart produced by photography, which is a technique, okay, which accurately reproduces the original. Okay? Kindly read section 4 of the Rule 130. Meron bang exemption yung original document rule? Meron po. Okay? Meron tayong exemption. This is the secondary evidence. Okay? Shortcut is CLAPCO. C-L-A-P-C-O. So, si original document rule, ito yung favorite na anak. Siya yung favorite. May exemption siya. Ito yung mga ampon ni document. Okay? Documentary evidence. 6. So, isa lang yung original na anak. Tapos, yung 6, mga ampon. Okay? Lang to, just to make na maalala nyo yung kwento. I'm not here to baka isipin nyo, baka may ampon sa inyo or adopted. Please do not be offended. Para lang maalala ninyo. Okay? The first one is those that are under custody or control. Number 2 is those that are lost, destroyed, or the production cannot be made. Those that A is for those accounts which are so numerous and cannot be examined without great loss of time. Ito yung super daming ng kopya. Nangyayari ito madalas sa mga resibo. Next are those public records or recorded in a public office. And additional, this is an addition. So I hope you are still listening to me. Bago. Additional. Hindi nyo to kung graduate kayo ng 2019, pwedeng hindi nyo na to nabasa. CO. The first one is those original not related to controlling issue. And next one is O, or those that cannot be obtained but by local judicial processes or procedures. Again, CLAPCO. CLAPCO. The additional is the co. The original is not the controlling issue, and lastly, the original cannot be obtained by local judicial processes. Let's go with secondary evidence. What are secondary evidences? Okay, the shortcut CRT. Okay, copy, recital in an authentic document, and testimony of a witness. Always remember that the proponent must account for non-production of all the originals. Okay, wait lang. Case. Before going to the case, kindly isulat nyo to please. Inscribe chattel doctrine. Inscribe chattel doctrine. This is new. Mga bago tong mga to So, those who are listening, you are lucky. Okay? Inscribe chattel doctrine. What is this? Here, a witness can testify that defendant hit the victim on the head with a Wilson tennis racket without requiring production of the racket. Under the inscribed chattel doctrine, a rationale for the original document rule, okay, the unreliability of witness memory is not applicable since the inscription tends to be simple and brief and hence easily remembered. Hence, there is no need to present the original writing. So, this doctrine is the rationale for the original document rule. Please remember that one. Baka lalabas yan sa board exam nyo kasi bago yan. Next one, case. Si defendant Pedro was charged with the crime of transporting a stolen vehicle to another place. Okay? Anna, the witness, testified that she received the stolen vehicle from Pedro. Oswald, an FBI officer, testified that he examined the trunk of the stolen vehicle and found a white shirt, imprinted with the laundry mark PED. Okay? The defendant objected. Okay? Pedro objected on the ground that the testimony of Oswald, the officer, violated the original document rule, and the prosecution should have been required to produce the t-shirt itself. Should the objection be sustained? The answer there is no. Here, in the given case, the case of United States versus Duffy, the imprinted shirt may hardly be recognized as a writing covered by the original document rule. Because the writing involved in this case, the inscription DUF, in our given case is PED, was simple. There was a little danger that the witness would inaccurately remember the terms of the writing. Also, okay, the terms of the writing were by no means central or critical to the case against Duffy. The crime charge was not possession of certain articles, where the failure to produce the article might prejudice the defense. In the given case, yung binigay kong case, yung shirt is only a collateral evidence, meaning evidence is not allowed. And even if it's allowed, it's only as to the probability or improbability. Hence, furthermore, it was only one piece of evidence in a substantial case against Duffy. That is the case. That is an actual case. Next. Ano naman tong another exemption doon sa original document rule na hindi mo kailangang i-produce yung original. Okay? Kung photocopy lang meron ka. Here, the original cannot be obtained by local judicial processes or procedures. Okay? The first part of the Section 3 of Rule 130 refers to the situation where the original is in the custody of the adverse party. In this part, mere notice is sufficient to avail the secondary evidence. On the second part, okay, it refers to the situation where the original is in the custody of a third person. In the given case, it's a local judicial process. Example, subpoena. Okay? So, subpoena is an example. So, the local judicial process must be resorted. Let's go with parole evidence rule. Ano tong parole evidence rule? Parole evidence. Ang parole evidence, sobrang easy lang yan. Kung walang agreement, walang parole evidence. Kung hindi nyo issue yung agreement, walang parole evidence. So, always remember that in parole evidence rule, okay, once an agreement has been reduced into writing, parole or extraneous evidence, oral or written, of prior or extemporaneous terms or conditions may not be admitted to modify, explain, or add to the terms of the written agreement. Example, bigyan ko yung example para mas maintindihan nyo. Noong April 1, 2021, si Sheila, seller, at saka si Bianca, yung buyer, gumawa at nag-execute sila ng deed of absolute sale over a parcel of land located in Sanchez Mira with the price of 1 million pesos. Okay? And it's payable in full upon execution. One-time payment lang. Okay? In suit by Sheila against Bianca to enforce the contract, okay, may Bianca introduce in evidence an email from seller na Sheila dated March 1, 2021 in which Sheila agreed that the price would be payable in 5 annual installments beginning from the execution of the deed of sale. Ganito lang kadali yan. Okay? Itatagalog ko para mas maintindihan natin. Si Bianca, yung buyer, pwede daw ba siyang mag-present ng evidence? Yung evidence na is email, kaya hindi yung agreement mismo. Pwede ba siyang mag-produce ng ebidensya, yung email, na nagsasabing instead na one-time payment yung pagbayad ng 1 milyon, ay 5 installment payment. Okay? Ang sabi ng korte, okay, no. Okay? The parole evidence rule bars evidence of prior or extemporaneous terms or conditions, whether oral or written, okay, which would alter the terms of written contract. Here, do sa given case, yung email was dated March 1, 2021. Itong date na to is mas maaga kesa sa April 1, 2021. Okay? In that case, that would alter the manner of paying the price. Since the latest is April 1, 2021, that will govern their agreement. Kung May 1, 2021 sana yan, that can be admissible as evidence for modification, explanation, or alteration of their contract. However, March 1 is mas maaga. So, in that case, the parole evidence rule, okay, bars the evidence of prior or extemporaneous terms or conditions. Also, remember na yung parole evidence rule natin, it only applies to written contracts, ha? Written contracts, meaning yung oral contracts, it's not. Written, kailangan nakasulat po. Okay? So, yung resibo, okay, which merely prove as a payment, is not covered by the parole evidence. Kasi ang resibo is not agreement. It's not an agreement. It's only a proof of payment, but it is not an agreement. And contract, under our law, there are 3 elements: consideration, object, and cause. And in such case, to apply the parole evidence rule, it must be in writing. Okay? How about mga last will and testament, ma'am, applicable ba ang parole evidence rule? The answer there is yes. Okay?